They aren't even trying anymore. What the heck am I talking about? I'm talking about the fact that the Department of Justice, the federal one, not the one down the street in your state, but the federal one, has put out 2 draft model language laws. These are laws that they draft the language and they're basically asking states to press copy paste to adopt them at the state level concerning safe storage, civil liability, and reporting of lost or stolen firearms. What the heck? How does this all connect? My name's Tom Grieve, ex-state prosecutor, criminal defense attorney. Let's get into it. So in June of 2022, there was this little case, you may have happened to hear about it, called the Bruen Decision, B-R-U-E-N for those of you on your lawnmower. The Bruen Decision completely changed the game. And I realize that a lot of people use that to the point where it doesn't really mean anything anymore. This is like the old school way of using that. Back when we may remember, us older guys, when that used to mean something. The Bruen Decision utterly reworked the constitutional analysis, framework, and field of Second Amendment law by, among other things, codifying. This is the way that we analyze whether or not a law or regulation will be found as constitutional or not. I'm going to go into more of those details later, but the bottom line is this. I don't see how these proposed model language laws that the Biden administration, Department of Justice has just put out comes anywhere close to sniffing the Bruen analysis test and making it through. Let's go through this quickly. I want to make sure that we hit everything as fast as possible for you. But first, be sure to show your support for the Second Amendment. Hit that like button, absolutely free. It not only helps out the Second Amendment by showing your support that, look, people aren't going to be taking stuff like this. It also, of course, selfishly helps this channel out. Thank you very much. And as always, I also look forward to seeing your comments. We're going to take this in turn. These statutes, when we're talking about the very first thing, which we're talking about basically the safe storage issue, these kind of laws are generally falling into 2 different types. There's the conditional storage aspects, and then there's the required storage aspects. The conditional storage statutes, that's, of course, another word for laws when we say statutes. The conditional storage statutes generally require that individuals who possess a firearm securely store that firearm when not in use. If A, they know or reasonably should know that a juvenile could gain access to the firearm if not secure, as well as B, they know or reasonably should know that a person present or residing on the premises is ineligible to possess a firearm as a result of state or federal law. So, for instance, your cousin Jimmy, who's a convicted felon, at least for the time being, until one of these cases gets knocked through to the Supreme Court and we may see a reversal, that person is, of course, a prohibited possessor. Check your local listings because I realize that there can be odd exceptions to those things. The bottom line is that required storage statutes require firearm owners as well as, of course, possessors to securely store the firearm at all times when those firearms are not in use. Now, some state statutes combine these types of the conditional, in other words, the condition or just always stored, for example, by requiring secure storage as a baseline and imposing additional requirements as well as liability when a juvenile or prohibited person has access. Now, the Department of Justice safe storage proposed law does this in a couple of different ways. It includes language that would require individuals who possess firearms to securely store such firearms at all times when the firearms are not in use. It further provides for civil liability where an individual's failure to safely secure a firearm results in harm envisioned by the conditional storage statutes, such as if a minor were to come into possession of a firearm or an ineligible person were to come into possession of a firearm. The person who failed to adequately secure that firearm could be held as civilly liable. That's code for you're gonna get sued a lot as a result of whatever injuries or harm come out of people gaining access to your firearms that you failed to properly secure. Now, as a note, some states do require a person who possesses a firearm to safely secure that firearm when they are not attended, only if a minor could potentially access the firearm. A couple of states that come to mind would be Florida, Texas, and Michigan. Other states also require safe storage when an individual who is ineligible to possess a firearm is present, such as California, Colorado, and New York. And still other states require safe storage any time a firearm is unattended, namely Connecticut, Massachusetts, and Oregon. This model bill generally requires any person who possesses a firearm to safely store the firearm when it is not under their direct control, with a limited exception, of course, for law enforcement, depending upon law enforcement policy and so forth. The penalties can vary from state to state, as well as depending upon the outcome. In other words, if a minor gains access to the firearm but no one's hurt, you could be looking at very different penalties as compared to if a minor gained access to the firearm and someone was hurt. And again, this is contingent upon the safe storage requirement. So many states, of course, do have laws on the books saying, hey, if a minor comes into possession of a firearm, that they're ineligible to possess. And if something bad happens as a result, penalties on the owner. But of course, here, this is contingent also upon the owner being in compliance with those safe storage laws. There are also, of course, some requirements built into this, as well as the next law that we're going to talk about, dealing with written warnings given to firearm purchasers at time of sale. So in the FFLs, the retail shop establishments. And again, what we're talking about here is model language. So generally speaking, state legislatures, they don't dream up, I mean, sometimes they do, but they generally don't just dream up and draft things. Quite often, they're copying and pasting from what other states, other jurisdictions are doing. And when I say copy-paste, I mean that often quite literally copy-paste. Maybe they make their tweaks, but it's often, frankly, a copy-paste. So there's these think tank groups that are out there. In our particular case, maybe it's an anti-gun group who drafts model language, or will hire some expert to draft model language to basically put out there on their website, just as the Department of Justice is doing here, to say, hey, we've done the work for you if you want to basically advocate or virtue signal or whatever particular topic we're talking about on this particular issue. Go ahead, copy paste this, put your name next to it as a sponsor or co-sponsor, and you too can be part of the solution, of course. Let's take a quick look at the firearm theft or loss model law. So this model legislation draws upon, again, the firearm loss as well as theft reporting statutes that have been adopted in about 15 states, including the District of Columbia, and is designed to identify the main features as well as some different aspects of these statutes. States that have firearm loss and theft reporting statutes vary to whether actual or constructive knowledge of the loss or theft is sufficient to trigger the reporting requirement. So actual knowledge, I had my firearm with me when I was doing X and now I don't have it with me. That's actual knowledge. I actually know I had it at this point, I lost it at the next point. Constructive knowledge could be something that it could be circumstantial, perhaps. It could be information that's coming to you from other means. Maybe someone said, hey, I saw Johnny down the road with your firearm, and Johnny ran off with it or something like that, right? Something like that. You may not have actually seen it, but now you arguably have constructive knowledge of the fact that your firearm, which you thought was securely stored in your cabin, in your car, your wherever, is now gone. There are a number of states, including Colorado, Delaware, as well as the District of Columbia, that basically have something like this, which is a trigger requirement that if something has happened, you are now triggered to have a duty to report it, right? If something winds up being stolen or lost. There are others that have actual knowledge requirements, such as Connecticut and Oregon, that impose the same requirements on persons with constructive knowledge. The states also employ a range of timeframes for reporting after the requirement is triggered. So for instance, you have to report your firearm theft or loss immediately, like in the District of Columbia? Or do you have, for instance, up to 7 days after the discovery of the loss, such as in Delaware? For purposes of clarity as well as ease of enforcement, the model legislation proposed by the Department of Justice, they claim requires reporting no later than 48 hours after the owner of the firearm obtains actual or constructive knowledge of the loss or theft. The proposed language also, of course, indicates that there's certain information that must be included to the law enforcement agency when you make that report, including caliber, make, model, manufacturer, and serial number of the firearm, as well as any other distinguishing numbers or identifying marks. At least 2 states, including Colorado and Hawaii, have included similar requirements in their statutes. Now, I want to just key in on something here. This also forces gun owners to create a registry, to create some place where they have a list of all of this information so that you have any hopes of complying with the law. Because if you want to comply with this law You have to be able to foresee that there's a chance that something could happen to your firearms when it comes to loss or theft. And in order to be able to be ready to comply with it, you now have to create a list, an inventory of all your firearms, make, model, caliber, serial number, as well as any other numbers to be in compliance with the statute. Wouldn't that be kind of happy? Wouldn't that be kind of fun and interesting to stumble across, of course, if all firearm owners were forced to compile all these lists? And I realize that there's lots of folks out there who are going to say that's perfectly common sense. Of course I do that. There's lots of folks out there who say, for numerous reasons, I refuse to centralize a list of all my firearms in one spot. This isn't about that. I'm simply pointing out that this law would, in essence, force that upstream decision and that conscious choice about compliance or non-compliance, and then, of course, the ensuing secondary effects, such as creating that list. Further, the law would require individuals to notify the same law enforcement agency if they were to subsequently find the lost or stolen firearm. We do see this in Colorado as well as Massachusetts. There's, of course, also a written warning requirement that needs to be provided at time of sale. Now, at least 6 states impose civil penalties, in other words, non-criminal penalties, so fines, stuff like that, for failure to comply with their firearm loss as well as theft reporting statutes, including Virginia, New Jersey, Michigan, the District of Columbia, Delaware, as well as Colorado. And at least 3 states classify violations as criminal misdemeanors. So in other words, we're talking crimes punishable by up to a year in jail, not rising to the level of felonies: Connecticut, Hawaii, and Ohio. One state is a hybrid statute where the first violation constitutes a civil infraction and the second violation constitutes a criminal misdemeanor. That's Maryland. And lastly, there's also a section in the bill to, of course, go after gun owners who decide to file basically fraudulent or materially false reports, similar to what you see in Hawaii and Oregon. And again, the bottom line issue that I started this with, and I want to end this with, is the fact that in order to justify this regulation, the government's going to have to show, they will have the burden of proof that this falls within the nation's historical tradition of regulating firearms. And generally speaking, if you're pro-gun, those traditions need to be sourced from the colonial times up to the early republic. So we're talking 1820s, 1830s. If you're anti-Second Amendment, or at least weak, let's say, you're going to be generally allowed in most instances up to about 1870s, 1880s, give or take, on a 14th Amendment issue. Because keep in mind, the Second Amendment did not apply to the states until the 14th Amendment in the late 1860s. Arguably, at best. Otherwise, we're, of course, up to McDonald in 2010. There's the real quick hits. I want to keep this one short because I'm trying to get it out today. Post up your questions and comments below. Do you think your state, what states will put this in there? What states will not? It's surprising that I saw Texas and some other ones have something like this. Is this good? Is this common sense? Should we all have this regardless? Should this be non-controversial? Or is this something that could lead to something much worse vis-a-vis the, hey, you now have to create a registry of everything that you have? I look forward to seeing that discussion in the comment field below. Don't forget to hit that like button if you haven't already. And of course, let's go ahead with our quote of the day. This one comes from Oscar Wilde. Quote, "Nowadays, people know the price of everything and the value of nothing." One of my favorites. Hope you enjoyed this video. I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.